Hello everyone, bonjour tout le monde. Welcome online or in person to Concordia University's ForSpace. Thank you so much for joining us on this rainy day for this panel discussion on artificial intelligence and the Data Act, the Government of Canada's first legislation regulation regarding artificial intelligence. We're so pleased that we have such a great group of panelists joining us today, audience members, active audience members from what I'm hearing, and organizers here with us online and in person. Just to let you know that we are streaming to YouTube live from Concordia University's ForSpace. And if you're unfamiliar with ForSpace, well, we're located on unceded Indigenous lands here in Tiohtià:ke, Montreal, And what we do here is work with our university community members as well as their partners to help mobilize and exchange knowledge by creating daily activities. And it's been our pleasure to collaborate with the Applied AI Institute here at Concordia and all of their partners and colleagues for this series of events, this being the last event of the season for now. We'll be back next year. Okay, I think that's going to be it for me. Should I pass it over to you, Fenwick, for some words of welcome?
Yeah, thank you very much. And so my name, for those who don't know, is Fenwick Kelby. I'm an associate professor in communication studies and also with Tristan Galtard, co-director of Concordia University's Applied AI Institute. Sorry, I can't be there in person today, but as you might tell, I'm getting over a cold. And while I'm feeling pretty good, I didn't want to infect everybody. So out of an abundance of caution, I'm moderating this panel virtually. Now, I'd like to say that this is a really tremendous opportunity, and I'm so delighted to have my co-panelists. This is a really big accomplishment for me to have together some of the top minds thinking around AI governance in Canada and more broadly. And really, in particular, I think we're at a tremendous moment right now with the publication of the open letter calling for an acceleration of Canada's AI governance and for real push towards AI governance. Now we're at a very public moment of debating, and after the eruption of interest in ChatGPT and really kind of the controversiality of AI going so public, this panel really opportunities a chance to reflect on the cornerstone of Canada's AI regulation and thinking through the ways and the implications of how the AIDA bill or the Artificial Intelligence and Data Act can or cannot advance the AI governance agenda. And really, to me, these are people that were so gracious to join, but also people that I greatly respect in terms of their insights. And so we'll be hearing from different perspectives around what AIDA does and does not look like. For those who are participating, we've kind of have 5 objectives for this panel for me, which is, probably a bit too much, but that's how I roll. We're trying to introduce what is the Artificial Intelligence Data Act to a general audience, situating this within the broader field of AI governance, elaborating on some of the central logics, which I think are really important to investigate about how AIDA works, talking about its effectiveness or lack thereof, and then evaluating what could be better approaches to AI governance. So with that, what I'd like to say is acknowledging my co-director, Tristan Galtard, also Lindsay Rogers, who I hope is in the room, who, if you haven't get a chance to say hello, has been the person instrumental in making this series happen and making sure this event happened. Lindsay is the Knowledge Mobilization Coordinator at the Applied AI Institute. And then those are the last word in the Applied AI Institute. One of the things that I think we're thinking about quite seriously is the intersection between AI's development and what is the way that it can, its social impacts are properly addressed and compensated for. And I think one of the parts for me is that this is an important point of interdisciplinary discussion where we have practitioners in computer science as well as critics, policymakers, members of civil society, lawyers trying to talk through. And part of the point of these discussions in this panel today is to try to foster, I think, better interdisciplinary discussions about AIDA and the future of AI governance. With that, what I'd like to do is I'd like to ask each panelist to briefly introduce themselves. I'm going in alphabetical order of their first name for no other reason, but they're all very impressive people in their own right. And so I'd like to first invite Bianca to introduce herself and maybe tell about how you became interested in AIDA.
Yeah. Hi, everybody. Thank you, Fenwick. really appreciate the opportunity to have this conversation. And just off the top, I want to say thank you for making this event accessible online. I'm joining from Toronto, and I want to acknowledge that we're still in a pandemic, and supporting people joining not in person and in person is wonderful to see. So thank you for that. I'm a partner at Digital Public. I'm the co-founder of Tech Reset Canada. And in both of those organizations, what we really work on is more participatory engagement in digital governance. So public interest digital governance, but really not what I think. What I think is, how do we get more people to the table in these conversations? So it's really about the process factor and how do we engage more in these issues so that we're getting results with how we want to manage technology, given all its societal and democratic impacts. A couple more points. One of them being, I am really, especially because of what I've seen in the pandemic, probably got that kick I needed to just see full institutional failure in the face of a crisis. And what that means to me is not to lose faith in the fact that we need institutions, but to understand that if we don't shift more power to the public in order to have more self-governance and more engagement on these issues, I really don't think we're going to get anywhere different than when we are, than where we are today. Lastly, I got interested in this topic because I was following the digital charter. And at that point in time, a few years back, it was one of these questions to me, is like, what, we have a charter. Why are we making a digital charter? Why are we reshaping some really fundamental things in the shape and name of technology? And I worked a lot on that question with Nasma Ahmed of the Digital Justice Lab. So just want to honor the fact that this conversation is longstanding. And so when C27 emerged and AIDA really seemed sort of glommed, if you will, I try to be respectful of the professional work that's being done, but looking at the way and the haste with which that proposed legislation was put together, I had questions both about the very concept of legislating AI as a thing. I don't agree with that, which we'll talk about more. And secondly, really concerned about the lack of public engagement, which brings us back to where I started. So that's the introduction, that's the connection to the interest in this, and really looking forward to the conversation.
Thanks, Bianca. And I think it's helpful as someone who myself got interested in artificial intelligence after doing telecommunications work. I find artificial intelligence policy slightly more hopeful than telecommunications policy. So to give you a sense of where I've been at, but yes, I think trying to also recognize that the ability of participating in hybrid events has been the result of decades of advocacy, trying to make sure that digital inclusion is possible, and that's certainly something we can thankful for Force-Space for enabling, but also I think recognizing how long these discussions were taking, that we're talking about today, have of a longer history and a much longer history. And hopefully we'll be able to talk a little bit about the digital charter as well. Next, we have Christelle Tisano. Christelle, maybe you can introduce yourself.
Yeah, thank you, Fenwick. Thank you as well for the invitation. Being here in Montreal is really exciting. So as you know, my name is Christelle. I'm a tech policy researcher based at Princeton University's Center for Information Technology Policy. And over the past couple of years, I've been studying AI systems in different contexts. So gig work, facial recognition, political advertising on social media platforms, to name a few examples. And this experience has allowed me to develop a socio-technical understanding of how systems are deployed in different contexts. And when AIDA was tabled last summer, I took that as an opportunity to analyze it. And a few researchers at the Toronto Metropolitan University and at McGill and I decided to write a report analyzing the Act from a human rights perspective. So I'm really excited to talk about that with everyone today.
Thanks, Christelle. And I think if you haven't, I'll find a link and put it in the chat to that report. But I think it's a really good, one of the first, and I think really thoughtful reflections on some of the consequences, which we'll get into about how AIDA is approaching this kind of AI issue, and looking forward with that discussion. Next, we have Florian. Florian, would you like to introduce yourself?
Yeah, so bonjour à toutes et à tous. First of all, thank you so much for the invitation. I'm delighted to be in conversation today with my co-panelists. I wish I've been in Montreal with you, but that was not possible. I'm joining you today from Cambridge, Massachusetts. At the moment, I'm a fellow at the Berkman Klein Center for Intelligent Society at Harvard University. But because I'm on sabbatical, but I am an associate professor of law and technology and the University Research Chair in Technology and Society at the University of Ottawa. So in Canada. And at URAWA, I led the Center for Law, Technology and Society, as well as the AN Society initiative. And so I'm a legal scholar, but I'm interested more generally in the impact of technology on society and how, from a policy lens, of course. And I've been working with many colleagues and people outside of academia. So not just in law on all of those issues about the digital charter, about like privacy, platform governance, blockchain regulation and policy and so on. And of course, I've been working a lot on AI policy, AI regulation in many countries, including Canada, and a few years ago, actually, during the pandemic, at the beginning of the pandemic, my colleague and friend Teresa Scassa and myself, we gathered a bunch of thought leaders in law and regulation in Canada to create a textbook on AI and the law in Canada, so reflecting on many of the implications and sometimes need for regulation, and other time no need for regulation because current legal framework can be used to tackle some of the issues. So that's a bit of my background, and so I've been very vocal on C27 as my other co-panelists. So I'm more than happy to be here today to share some thought and be in conversation with people from civil society, because as Bianca mentioned, we need to have to be conversation and engagement about this act, but also people in government and in industry. So I'm happy to see like such a diverse audience today. I'm sure the Q&A session is going to be even more amazing than the conversation between us. Thank you so much.
And Florian, I think it's also important, as you mentioned, is trying to think about what voices we're trying to include. And I think one of the parts for me in the panel was making sure that we had a diverse, approaches who is coming from the law, trying to have members of civil society, legal practitioners, those with international perspectives. So that's, I think, one part of this is that one of the hopes for this is to not the foreground how we're approaching this bill, trying to understand just in a way that's meaningful, the social impacts of it and the ones that touch upon it, just not simply as a regulation matter, but one that, as we know in Toronto and other cities that have, had long controversies around facial recognition technologies, that are ones that are impacting people's everyday lives. So that's something I hold with me in our discussions here. And then finally, and last but certainly not least, I'd like to invite Marussia to introduce herself and to say a few words about your work and how you came to be interested in AI regulation or AI law more broadly.
Thank you, Fenwick. Et bonjour tout le monde. It's really a pleasure to be back here at Concordia, my alma mater. So I'm thinking through this from a systemic perspective, trying to think about which stakeholder is best placed to determine AI policy. When does top-down regulation make sense? When does self-regulation make sense? And what is the role of impacted people in all of this? So I'm a doctoral candidate at Harvard Law School, and I come at this from having been at Global Affairs Canada as a senior policy officer, leading the AI and human rights file back in 2018. So governments were starting to think through the implications of AI for foreign policy. And Canada led the G7 that year, and AI was really at the heart of discussions. And so we started thinking about, what does a rights-based approach mean for AI? And so for me, that's the baseline, kind of the lens through which I'm looking at subsequent developments. Basically, are we walking the talk when it comes to protecting Canadians from AI-driven harms, all the while promoting innovation? So human rights is really our calling card when Canada sort of presents itself abroad and tries to build coalition with like-minded partners. We are really pushing for a rights-based approach to AI policy. So when I look at AIDA, I have this question, which I'm sure we can expand on today, is, are we implementing this at home? So I'll leave it to this for now.
And I think, Marussia, one of the things that's really important is trying to situate AIDA within the kind of broader global context that which you're at work here. And certainly we have the EU AI Act And Canada also has a number of different partnerships around AI. And I think that that's certainly part of what we're hoping participants learn today. Is not only about kind of Canada's approach to AI and AIDA, but how that kind of works more broadly in comparative cases, and how that, Canada is leading or not leading. Because certainly I think, it's been the experience of myself as well, as Canada is now being perceived to be or expected to be a global leader around AI. And how is it feeding or not meeting that role and responsibility? So I want to pivot now, and I want to thank all of our panelists for their great introductions. And I want to pivot now to really starting to talk about some context and giving context to where AIDA is coming from. Now, as Bianca kind of mentioned, AIDA came to many of us as a surprise last year, and that this was part of a long-standing process about privacy and the personal information reforms in Canada. And this has been a perennial project of many governments is trying to do privacy reform. And I was wondering, Florian, if you'd be able to situate where AIDA fits into that history, maybe mention a little bit about the digital charter that was mentioned previously and how AIDA is part of the latest iteration of reforming privacy law in Canada.
Yeah, so no, exactly as it was mentioned before. So AIDA, so the AI and Data Act, short name AIDA. We can maybe reflect on the choice of the name and what the acronym means later on, maybe as a conclusive remarks for this panel. But it was introduced in Parliament last June as a real surprise, and I think we all got quite excited when the Minister of Innovation, Science and Industry gave notice to the House about the reintroduction of the privacy reform with this kind of Easter egg in the bill. Very quickly, we got way less excited when we started to read the bill, but I will come back to this a bit later. And so, as it was mentioned before, the bill came to a surprise, but is the result of like a very long conversation in Canada within civil society, within academia, following a series of scandals both in the public and the private sector, and quest for protection from Canadians. So for privacy, a lot of conversation. Like in Parliament, the House of Commons published several reports in the years. But the need to better protect the privacy, the data protection of Canadians, the need to regulate AI systems, etc. And so in 2019, if I remember correctly, the then government, Trudeau, it's not the same, but still the same prime minister, but the government published a digital charter. And a lot of people got excited, but something to keep in mind, the digital charter is just a political statement. It was basically the electoral platform of the Liberals for like the digital electoral platform for the upcoming federal election. This is not like a charter in the sense of, the Canadian charter that actually protects Canadians. I'm guessing that they choose that name as a reference to send a signal to Canadians that they were willing to finally act to reform privacy law, competition, telecom. Like there is so many things in digital charter. It was a very welcome sign. Since nothing really followed through. In 2020, so the former Bill C11, not the current one, that's confusing. In the previous parliament, the government introduced Bill C11 that was proposing a reform of AIDA, so the private sector privacy protection framework. So reform of AIDA still including some much needed provision about the processing of personal information by AI system, and some framework about protecting and proposing some data governance for anonymized data. This bill died on the paper order because the federal election was called. And for several months, we waited, even though the government was telling us that privacy, etc., was very important to them. We had to wait until June for Bill C-27 to be introduced. And so reintroducing the Canadian Privacy Protection Act that was in C-11 with a few modifications that we can talk about later. And so with this Easter egg of AIDA, and I'm going to be a bit cheeky, but it was like mentioned, I think, before by Bianca, with a very interesting process. So the bill is tabled. Then the Minister of Innovation, Science, and Economic Development teams engaged with several stakeholders. And then a few weeks ago, they published the companion document. That is kind of a white paper proposing an approach to AI regulation. This is quite innovative, even though I know it's the Minister of Innovation, because usually government will, and all other governments, around the world have been doing that kind of regulatory work. They publish first the white paper, then they engaged in public conversation with all stakeholders, and then they table a bill. So just on the process side, and I'm sure my other companies will have many things to say, this is interesting to say that.
Thanks, Florian. I think that also becomes helpful because you can, for those who are kind of new to this world, can understand just the scope of what's being proposed here, is that it is not simply an AI bill, but it's part of a wholesale reimagining of our underlying privacy law. And these have many kind of issues that are kind of central to artificial intelligence. Well, when we talk about de-identification, anonymization, algorithmic decision-making being used, C-27 touches upon that, as well as I think questions of what will be the future of the enforcement of these rules and the future of something like the Privacy Commissioner, which has been long kind of support. Its mandate has been subject to a lot of debate, trying to encouraging it to have a broader mandate and enforcement powers. And then, as we'll get to, the AIDA bill also puts forward a new data commissioner as well. So lots of moving pieces here. That's an important.
Yeah, exactly. So if I may add just one extra minute on the regulator part, because I think this is super important to understand the background. It's also so C-27 is part of this long-standing conversation of Canadians, industry, civil society asking to have actual regulators to protect Canadians. Because at the moment, the Privacy Commissioner of Canada has close to no actual powers, no order-making powers, no enforcement mechanism, cannot find and cannot build cases against some of the big tech, as we've seen in the past days. So this is the big issue. The House noted this in many reports. Our partners have been calling for this. So this is one of the things that is proposed by C-27, finally giving new teeth to our Privacy Commissioner. And also for the past years, we had heard about a new data commissioner that would help to maybe make more sense, of data governance within the public sector and the private sector in Canada. And so Bill C-27 in AIDA also proposed a regulator for AI system. But in my opinion, it's what could be said a fake regulator. We'll discuss this later. Does not answer any of the concept that was highlighted by Canadians. But yeah.
Well, thank you. No, I think that I just want to make sure that people understand some of the context here, and this is helpful. And that's why I also wanted to turn to Bianca, because as someone who's been involved in a number of notable controversies around data and data governance preceding AIDA, and these calling for reforms to existing approaches to data and privacy, I'm wondering how you might situate this history of where AIDA comes from, and how does it fit into what I think is importantly not only a history of regulation, but also a history of civic activism and about calls and greater demands of civil society activity, calls for greater demands around data and pursuing issues.
Yes. So I'm going to be the person, I think, if anyone wants to join me in this, please do, constantly pulling us out of being too specific about AIDA without looking at some of the older and more institutional or political constructs. So one of the ones that I want to start with is ICID is the author of this legislation. ICID has a mandate for economic development. So we have to start with asking ourselves, if we're talking about human rights and social implications and all the rest of it, and if we're really going to get, I mean, I don't buy into the rhetoric at the moment in terms of how important it is to look at AI, but we're very happy to forget all the trouble we've got with everything before it, right? So having said that, I mean, if we want to take it as seriously as we are, I think we have to stop and ask ourselves, what does it mean when the frame and the pen is held by an organization or, you know, the part of the government that has a mandate for economic development? And so that's one thing that I want to raise. And I want to bring us back to the year, at least 2000, courtesy of some work that Val Steeves did, and remind us that when PIPEDA was created, there was significant conversation about the fact that human rights and trade were getting intermingled and mixed in a way where there were trade-offs going on human rights in order to facilitate global trade. And so I think we've had a problem with, and you know, to speak to our issues of human rights in here, we're 23 years into subsuming human rights into trade structures. So those are two things that we can't just, you know, start from this act and go forward on. I think if we want to be as serious as we should be in this moment, we really need to be looking back and asking ourselves about undoing some of the things we've done as rather than accepting them as constructs and getting sped along into what to do for data governance and artificial intelligence governance at this moment. A couple more things. There's a paper that Meredith Whitaker wrote in 2021 called The Steep Cost of Capture. And this really looks at the fact that the people who are holding the computing resources and the capacity are completely, you know, large tech, private sector firms. And so when we think about, again, the democratic implications of having these conversations shaped by actors who have a commercial and a profit motive, which is not bad, it's just not the same thing as democracy. So when we're talking about what it means to bring people their rights and their capacity to hold governments accountable for their rights, all different kinds of rights, we have to really be honest about the construct in which we're having this conversation, and that consumer protection is a very, very different animal than accessing human rights. And again, on the rights piece, your rights are only as good as your access to them. We don't have good access to justice infrastructure in this country for every other right that we propose to support. So I think, you know, to this idea that Canada likes to hold itself up as the human rights proponent globally, we don't have to look far in terms of nation to nation sovereignty conversations to understand that we're not upholding human rights in the country domestically on things that are older. So just don't want to, you know, minimize that either. So I guess just two more things in terms of, I'm trying to keep the through line here, democratic participation. Something else that I was part of in an advocacy perspective through the pandemic was COVID Alert. And so when we talk about the power of the privacy commissioners, it's really interesting because I think, not coming from a privacy background, we're at the point now where privacy is being productized. And if we can say something is privacy preserving, it doesn't really matter what it is anymore, which is a major problem because there are so many other implications to technologies and their application and how they're used. And I think what was fascinating, what we saw with COVID Alert, is you had the federal, territorial, provincial privacy commissioners all say, do not make technology mandatory during a crisis, a public health crisis. And what did the Liberal government do? They did it anyway. And if we can't understand how actions like that have been increasing and fomenting some of the polarization we're seeing, we have to understand that these issues are in some ways furthered by state decisions that are made on how technology is applied. And so it was fascinating to me that there was nowhere else to go. The privacy commissioners all said, don't do it. And I was like, yeah, we're doing it. So there are issues that we have with the use of technology that are upstream of privacy. And I was reminded the other day of a really nice paper that Frank Pasquale wrote, The Second Wave of Algorithmic Accountability, which gets us into the conversations of not just, the fairness, accountability, transparency, but the should we build it or not? And I think to add on to Frank's framing is should we write laws around it or not? Because that's another question that I don't think we're asking enough. We're all gonna, barrel forward into this conversation. So I think the last thing I want to say is, and I think it's funny that the government's saying it's not really a charter, it's kind of a charter. It's this is so par for the course with just like making things confusing and theatrical, and it looks like something's going on. But what was really disturbing, I think, in the urban conversations around the use of technology, what we saw in Toronto, was the excitement with which adding data or digital to something sort of reduced and removed all of the known issues, all the tacit knowledge that is held within the communities that have a lot of power, positional power, urban planners, city governments. They know what their problems are. If you ask an urban planner what their top 10 issues are, access to data wouldn't even be in the top 10. They would tell you they need to design the data collection they need to know if their policies are working or not. And so we saw this in the city. You're going to see it with healthcare. You see governments saying, okay, give all the data to tech companies, give them the administrative data, and maybe something great will happen, which is wild because it's ignoring all the expertise we have where people know what the problems are, whether that's the public or whether that's a professional who has a duty to show up and make sure that people's rights are respected in the use of technology. So these are sort of a mixed bag of some of the contextual things that I see as a little bit, in some cases a little bit concerning and maybe addressable, and other ones like fundamental issues philosophically with the approach of AIDA. But I hope that that's helpful in terms of seeing, like if we're privatizing access to, firstly, even understand how these technologies are constructed on one hand, but also governments are applying technologies that they have no access to in the delivery of public services that implicate our rights. That is bananas. That's what happened in the pandemic, is the government was telling people to stay home based on a glitch from an infrastructure that they don't own and they have no contractual power over. So we're now actually, we're sticking these technologies right in our public service delivery. And I think that should give us massive cause for concern. So I'll stop there.
No, thanks, Bianca. And I think that there's a number of parts there. And one part I'd like to return to is some of your own, which I'm hearing from you, is some of the criticism about whether we should have AIDA in the first place. So I'm hoping we have some time to return to that because I think it's an interesting point of perspective. I would say that one of the things that I've really had the privilege is along with a lot of the researchers at the Shaping AI project, is really starting to realize that some of the discussions that we're having now around artificial intelligence aren't about the technology itself, but really profound changes to the state administration. And how do we think about this? This bill is one part, but as this, I think, wider question about democratic accountability and what is the public service doing in terms of service delivery, or hesitate to use that word, but in terms of its responsibility and mandate. I think one part to connect it to, and I wonder kind of link up to something Marussia said at the start, is about what stakeholders are being involved. And in terms of how do we think about this bill itself invoking a certain degree of participants, and how that might relate to the EU bill. Because in one sense, the EU bill is also tasking certain ways of organizations classifying what can and can't count as high risk, or who's doing this type of assessment. And I'm just wondering if you might, as a way, think about how the EU bill is like or not like the Canadian AIDA bill in who's it's invoking. And I think raising these questions about who's being involved in these conversations about how the bills are being formulated and rolled out.
Yeah, well, I think at a high level, it's safe to say that the EU drafting process was much more inclusive and democratic. We see both industry-led groups and civil society coalitions coming together and having the time to actually go into details, provision by provision, and providing input. And the timeline for AIDA hasn't allowed this to happen. And I would also note that between the first and the second reading, there didn't seem to be a lot of change in the bill. At a higher level, I would say that the EU bill is much more context sensitive. It's much more clear. It's much more detailed. We may not agree with the provisions as they are, but at least we know what they are. And in AIDA, a lot of the kind of meat is to be announced. It's to be defined in regulations. So we have no sort of text to chew on to have a democratic debate about. And so I think that's like a high level difference. And I would also say, like, this is AIDA. It's 15 pages. The EU bill is about 100 pages. It has annexes. And so, you know, that is a testimony of how more detailed it is. Other kind of similarities is that they both take a risk-based approach, but the EU context is much more detailed and granular. It has 5 tiers, whereas in AIDA we have high impact and sort of regular impact, so to speak. So in that sense, it's much more coarse. A similarity between both is that there's a heavy reliance, I would say, on self-governance. In AIDA, a company basically determined for themselves if they're high risk. And then they monitor their compliance. So it's unclear that they have the right incentives. Even the best meaning companies, you know, will face significant pressure to possibly downplay the risk that they pose. In the AI Act, there's also a component of self-governance, but it's less so. Companies that do use, they're called harmonized standards, they self-assess whether they're compliant with those standards or not. And it's unclear who exactly is going to draft these standards, but at least they will come from some sort of external organization. And then another kind of similarity is that a lot of the specifics are delegated to other documents than the actual law. In the EU, these are technical standards, and in some ways, the standards are actually ahead of the law. So Senelec, which is the body, the standard-making body, has actually started drafting standards before we even finalized on the law. So the implementation is moving forward quite fast. In AIDA, we have regulations to be announced that deal not only with the specifics, but also the general concepts of the law. So that is a cause of concern. I mentioned a difference in comprehensiveness already. Another significant difference is that the AI Act bans simply puts off the table certain types of AI systems. The list is still the subject of debate, but there's 4 or 5 types of systems that are just considered too dangerous to be on the EU market. We don't have an equivalent in the Canadian proposal. In terms of enforcement, Florian has mentioned it. I think this is something that we should come back again and again on because it's a significant shortcoming, one could say. In the EU, there's external independent public authorities that are in charge of enforcement. It's not perfect. We've seen with the GDPR, so the kind of similar data protection regulation, similar but different, but similar enough that I can make the point here that it is an external body. They've learned from their lessons in that space where the Irish Data Protection Authority had insufficient capacity, so they made sure to beef it up for the EU AI Act. In Canada, we have the AI and Data Commissioner that's embedded in ISED, so answerable to the minister. So the department is judge, jury, and executioner, as Florian often likes to say. I hope I'm not putting words in your mouth too much, Florian. At any rate, this is a big sort of difference, the enforcement, because at the end of the day, it doesn't matter what the substantive provisions are. If they're not meaningfully enforced, they will remain symbolic. And I think we can all agree, even if we have differences in sort of the specifics of the law, that we want the law to be actually enforced. So that's sort of an overall portrait of the differences and similarities with the EU space and stakeholders.
No, I think that's immensely helpful. I think important really of recognizing, when Canada talks about being a leader, it's like, how do we compare? I think pointing out key things about complicated risk, like a 5-tier risk assessment, the consultation process. These are really important ways of defining that even though these two bills are concurrent, they're the result of very different processes. The other part that I'd also mention, which is significant, is the ability of listing in advance what are the high risk or what are the problematic use cases about artificial intelligence technologies. This is something that, there was an opportunity in Canada to kind of identify that around facial recognition technology, particularly in the light of the Office of the Privacy Commissioner's decisions on Clearview AI. So all I say is I think that's one of the also questions is, in seeing that gap, how come certain technologies have not been flagged in the same way as they have been in the kind of EU context? And with that, I'd like to, and thanks to Christelle for being so patient, it's a talk to Christelle about one part, the voice that's important here is that civil society has signed, and civil society, I think, wrote very importantly the other open letter, which is not getting the near amount of coverage. And that was something put forward that basically states that while regulation is urgent, it offers an inadequate response and would cause more harm than it is good right now. And I think we've a lot talked about, I think specifically some of the kind of shortcomings here, but I was wondering, Christelle, if you could summarize some of the ways that civil society is seeing AIDA as being inadequate and trying to push for, I think, importantly, better AI governance, which is, I think, a key theme of that letter. Is not that there isn't, this is not something that's not problematic, but something that has to be done better.
Yeah, thank you for that question, Fenwick. There were multiple concerns raised in the letter, so I'll maybe summarize the 4 most important ones. First, the lack of public consultation, as mentioned by Bianca earlier, is a big problem. The fact that consultations on the bill happen closed door ensured that civil society groups, researchers, and historically marginalized communities were shut out of the process of writing the bill itself. Second, the proposed oversight with the AIDA commissioner is arbitrary and the enforcement mechanism is very fragile. And coupled with the fact that regulation is yet to be drafted, this makes scrutiny and accountability very hard. And the companion document mentioned that there will be public consultations after the bill has achieved royal assent, meaning that like after it passes through the House of Commons, Senate, it is passed and all of that. That doesn't seem very democratic to me. And I hope that like I'm able to repeat that as much as possible because it makes no sense. Third, the fact that the Act doesn't apply to government institutions is a big problem that was raised amongst my conversations with civil society organizations. We're talking about national security agencies not being included in the Act. And a few years ago, the RCMP unlawfully used Clearview AI, which is a company that provides facial recognition technology services. So the unlawful use of that technology by law enforcement wouldn't be covered in this Act. And there are multiple other agencies who could be using different types of AI systems. In the US, ID.me was used in order to access basic government services. So I could foresee how the revenue agency, I forgot the name, CRA, Canadian Revenue Agency, could potentially use biometric identification systems. And there wouldn't be any like adequate oversight aside from like the directive on automated decision systems by the government, but like that, the fact that it's so disconnected, not centralized, like it creates a double standard, and it's very hard to be clear around that. And lastly, the Act doesn't address the core human rights implications of AI systems. Instead, it focuses only on like biased output as a way to tackle harms, which does not really help. And I'm happy to like talk more about that later in the talk, because it's one thing to talk about, oh yeah, like we don't want biased output, but like it's not about the output, it's about the context in which the AI system is applied that is problematic and that we need to legislate around.
Thank you so much. And I just shared a link to the letter if people would like to read, but I think that's a really important distinction of these kind of key points. One part that I think is also important about this is that this is a really important moment in literacy and literacy around approaches, and that when we talk about this rich nature, I think I'm always struck by the kind of need for better awareness, kind of better buy or better public attitudes towards artificial intelligence, or being mindful that's part of the legislative process is actually building that capacity and interest. And one thread that I'd like to talk about, and this is something I'm going to open it up for all the panelists, but Christelle, I was hoping you could begin with, is that what type of approach does AIDA take? And if someone's looking at this bill, what would be, what's its underlying framework or way of dealing with this problem? And why is that significant? And what other alternatives might there be?
Yeah, I'll go ahead. And so when I first read the bill, I found that the approach wasn't very clear. And when the companion document came out, the government stated that they're using a risk-based approach similar to the European model because it seeks to regulate high-impact systems. However, to do that, the bill would need to define what a high-impact system is and outline the risks and harms associated with them, which it does not. It would leave to regulation, again, that is yet to be drafted. And I remember Teresa Scassa discussed that this is a very problematic approach, focusing on high-impact systems, because there are different risks that are present in any level and application of an AI system. In terms of alternatives, our report proposes an independent regulatory framework with a human rights approach, which centers individuals and communities, meaning that we would first want to identify the technology's human rights risks and then provide obligations and rights to properly address those critical risks. In the context of, again, facial recognition technology, this means not like wanting to have accurate technology, but rather like ensuring that facial recognition technology is not used to uniquely identify people in crowd settings or to access basic government services. Yeah.
Bianca, I see your hand up.
Yeah, and I want to talk about this contextual feature that Christelle raised in terms of what we could be doing instead. Before I do that, I just want to mention when I was talking about COVID alert and then mandatory technology, the mandatory technology would be ArriveCan. I just want to clarify because COVID alert was not mandatory pandemic technologies. So in the what could we do instead question, I just want to propose, if we think about, we've got privacy as a construct, then we've got data protection. I think for those paying attention to these conversations are saying, data protection is important to engage with in thinking about artificial intelligence, like privacy is not adequate. But the third, and maybe the place to go into novel, if you will, governance is contextual, specific self-governance. And so we have to, because I think this approach here about generic and risk and high risk and low risk, exactly as Christelle said, and Teresa Scassa has written and others, that's a contextual question. And you need to get into the specificities of any one case to understand, sometimes it's the 11th step in a process that might seem like some minor administrative nothing that breaks someone's access to housing. For example, in a evictions process that has been recently automated. If you look at the province of Ontario, we have some good examples. So something that may seem so mundane and administrative actually would be super harmful to someone and have a major negative impact. And so what I mean here, and this is the problem with the Canadian construct in a way, is you would have to really fund and support real engagement, like real ongoing, persistent, representative engagement, both from the public and from, I would argue, Sean McDonald and I have been working a lot on duty-bearing sort of professionals. If you're a doctor, if you're a lawyer, if you're an accountant, if you're something, you have to think about what your legal duty is to the people who you serve as part of your professional credentialing, and that includes urban planners. Right? So there's a whole bunch of professionals who could pick up some more weight and responsibility here. And so I think that's the direction to head. is more of that, which is so different from what's proposed here. But that would be a totally different kind of enabling legislation. That would not be an ISED, that wouldn't be it wouldn't make sense if that's coming from ISED. That would be expensive. But really, if we want to do it, I think to get, past also this innovation versus harm thing, there is, and I have to say this very clearly, and I'm going to repeat this often, there is beneficial use with some automated systems that is not innovation, and it's not commercially a thing. It's just using technology to support the public interest. That may not be a commercial proposition, but the state and our money in the ways that we invest in technologies needs to support that. Because if there's pro-social efficiencies that are beneficial for the public, we should, of course, be investing in them. So I just want to, close on the fact that moving towards specific contextual governance where you're taking a very specific case, that's what law is supposed to be about. If we're just doing pattern matching stuff, we're really getting away from the very notion of what law is supposed to be too. So I think we need to hold that there. But there's a lot of opportunity there, right? I know we've talked a lot about where this isn't great. There's a lot we can do there. I'm curious what others think.
Bianca, I think one thing that I'd stress also is just one thing for me is the difference between a kind of harms approach, which is part of what AIDA is about. And I think I'll respect that people interpret the bill a bit differently, but this kind of emphasis on harm versus kind of the potential of emphasizing key rights, as you're talking about, we're not always looking at kind of negative applications of this, but what are positive applications? What are the ways that AI is allowing more efficiencies or ways of digital technologies? I think you were the word pro-social behavior or pro-social outcomes. I think that's one of the things that you can also think about as a distinction. But you were raising a number of questions, kind of constitutional questions and legal questions. I thought, Florian, this might be a good time for you to chime in, just to kind of add your 2 cents to this discussion.
Yeah, no. So I think Christelle and Bianca did like a very good job at lining out some of the kind of structural issues in the way even like the bill was designed, because as Christelle mentioned, we kind of know, but we don't really know what the bill actually is. It seems to be a rights-based approach. Is it like the EU approach or not? We're not sure. Is it like a harm-based approach? Like in the companion document, they say that human rights was at the core of the act. Don't know where, because lately the Minister of Innovation, Science and Industry and his staff are like saying that human rights and the rights-based framework was not possible under our constitution because the federal government didn't have the competence. I was a bit surprised to see, I disagree with the constitutional, position, but it was very surprising to see human rights arriving in the common document. And that's something to keep in mind in just the cultural basis for the act, as Bianca mentioned. So first, that it comes from the Minister of Innovation, EZ, the Innovation, Science and Industry, so Minister of EZ, is questionable. Maybe could have come from another minister or be co-sponsored by many departments. I think that would be wiser. And the trade and international trade, commerce, is the constitutional basis for the act. So this is something to keep in mind. And also criminal law. Again, is criminal law the best way to regulate those kind of behaviors? We know that criminal provisions against corporation don't work that well. There is so much to be discussed, and just even those choices are very strange within Bill C-27, because AIDA is restricted to federal jurisdiction, trade and commerce. Well, CPPA, so the privacy reform, it still has the same constitutional basis, but is way broader. CPPA, like the current AIDA, applies all across Canada, including in the provinces and in provincial jurisdiction when there is no provincial statutes. So I'm very curious how this is possible for CPPA and before for AIDA, and AIDA has been around for 13 years now, and this is working very well. It has never been contested in court. Like we know that AIDA applies across Canada. How come that was not an option for AIDA? The other thing really very surprising is if you could discuss, like the extent of the federal power to some industries, there is no question about public sector. The federal government can regulate the federal public sector. They did not. Like the AIDA explicitly excludes the whole public sector from the act. And I think this is extremely problematic for many of the reasons highlighted by Chriselle and Bianca before, because like this is where we need, in my opinion, more urgently, like some regulation and some good governance and good framework is for the public, the delivery of like public services and administrative decisions. And what really kind of mind blowing is we have something. So the TBS directive, the directive on automated decision making that was mentioned before, is a very good document with an actual framework, for like assessing risk about like individual but also collective harm. So we have something. It's missing enforcement because it's just a directive, but still we had something that was applicable and that is like currently like applicable within the public sector. So why didn't we build on this? We could have just like transferred that framework and apply it to both the public and the private sector. And the other like big issues, in my opinion, about the AIDA is the delegation. Everything is delegated to regulation. This is an empty shell. There is like nothing, as Chriselle was like mentioning. That's a big issue because the regulations are like welcome. They bring flexibility, and in CPP and in other acts, there is many technical things delegated to regulations. But in AIDA, it's like the core element or the framework that are delegated, including some that might be the basis of criminal provisions. So that's extremely problematic, in my opinion. And I think, Bianca, you wanted to jump on something.
Well, just quickly, I think the fact that it's from ICID is exactly why I don't want it being a thing that's applied to the public. Certainly, public service delivery is a non-commercial. I know we all know this, but we're really losing track here. Like we're merging the. I think it's beneficial that we have a Privacy Act and PIPEDA, and they're separate. And I know some people argue. I think Colin Bennett is here. That the benefit of I can't make this argument. Data protection. Just treating data as data. Just treat it as a thing unto itself. For me, personally, when we're in democratic decline, I think it is highly beneficial to be crisp about the kinds of things that the state can and can't do with the data it holds, and a very different situation going on with the consumer protection and private sector thing. And Florian, I know what you're saying, like you can borrow some of what was thoughtful there and move it over. I know there's work there that could be moved over, but I would be nervous of it living under the remit of ICID. And then, even if we had great clarity between in the ways that we do of sorts with the Privacy Act and PIPEDA, there's so much, and this gets back to the point of who's holding the AI and then the computing power and all of the technologies. It's all private sector anyway. So now we've got the state using private infrastructures and then sort of pretending it's, that's why we have these really structural foundational pieces that I think would encourage all of us to rethink what we're doing, because we're sort of pretending that those things aren't there, right? Like the government sort of procuring things, and if it wanted to, it could build it itself. Like, no, that's not what's going on here. And we know how much the state, one thing I've learned over the years in doing work for government is consultation and other things that the public does. It's used as a liability reduction. And so are contractors and vendors. The state wants someone to blame when something goes wrong. I don't think that's good for us in a democracy, but the majority of the technology is being purchased. So it puts us in a really bad place for access to justice. So that was like, as you said that, I was sort of like, I hear you, but also like, this is another reason we don't want this moving through ICID, because the incentive is perverse. for what we're trying to accomplish here if we really want to talk about giving people access to justice. Like it's such a different construct. One more point, because I know so much of the conversations about artificial intelligence go back to data and digital. As someone who's worked with data for a long time, I just want to put forward this term because I think it's really useful. And if you look into these eras of like knowledge management, you can find this one, tacit knowledge. Tacit knowledge is by definition the kinds of things that people know that they have a really hard time verbalizing, writing down, putting in instructions, codifying, putting into data. And so, this is why these conversations philosophically about artificial intelligence and everything, like we really need to acknowledge that data is not a proxy for some of the most important things that we are working on right now. It really is, I think, Fenwick, like as you were saying, that we are at a bit of an inflection point. If we do not understand that data it's only a proxy for a certain set of conditions. Like it's not anything near the kind of intelligence that we need to bring to bear on the multiple crises that we're facing. And so I just think it's really dangerous when we start to treat these data piles as though there's something more important or more intellectually, important to our future than they are. Like we're all here. We know what we need to do. It really doesn't have to do that much with automating, unfortunately. Not that automation can't be helpful, but I just want to say that because I think sometimes we skip over and we sort of reify data as though it's, just because we have so much of it, it's going to help us. I don't think I know that's not always the case. So what does this bring us to beyond the point related to artificial intelligence? It also gets back to enforcement. We don't need to build a house of cards on top of technology. And that's what all of this is doing. You're adding complexity, you're adding a new political economy, you're adding new auditing firms. Like, do we need to go back to the years of auditing companies to understand why this model does not work? We're not even remembering recent corporate history here. So just want to put all of that out there. I'm curious, I know people wanted to return to the enforcement question, which I think is really important. But I have a hard time taking some of this seriously when there's so many of these question marks and a whole bunch of people who are like highly incentivized to go narrow on this as though it's, something that it's not. So I'll stop there. I'd love to go back to the enforcement questions and keep learning about the specificities. I just don't want us to fall down the rabbit hole of this thing and, treat it like it's really making a ton of sense. Because honestly, the thing is not anywhere near baked. Like, this shouldn't be law. I don't know how this gets out the door. I said I was finished talking. Honestly, I'm not. I have to say one more thing here. I don't know what the government thinks the public needs to see in a democracy to encourage trust. But writing stuff like this at this level where you read it, you saw it held up there, 15 flimsy pages when something's supposed to be really important, doesn't look good. And I think we need to add this to like democratic crises pile, is that we're just legislating for performance now. Like this is fundamentally sort of making people look at the government and say, as John Ralston Saul always likes to remind us, the government doesn't like people and the government doesn't respect people. That's not how the state operates. And this is like one of the best recent examples I've ever seen. Okay, I'm done.
Okay, yeah, I feel as though that's good closing note in some ways. We're coming close to our end of time, but I want to make sure we have discussions of enforcement. I'd also like to say that, Bianca, in one sense, you're talking about two parallel tracks here taking place. Is that one, there's a lot of discussion about what's going on in terms of artificial intelligence and technology in government, and raising the kind of the risks about that, as you mentioned, about the ability of governments actually being able to effectively govern with such limited access, understanding of how these technologies work. And then in tandem, for the bill, the AIDA part of the bill, which is dealing with these kind of large companies, how well or does not it address kind of the concentration of power, as you mentioned with Meredith Whittaker's piece. I mean, if there's a consolidation and we see a greater global consolidation of a few different firms, that does raise certain like mission critical functions, but whether AIDA is responsible enough to deal with that secondary issue and keeping both those in parallel. And I'd say there's another kind of key point. There's so much inflection that's taking on. I think one thing for me is that certain questions about the commons or certain ways of understanding public knowledge and literacy are kind of now being kind of taken for granted as something that could be easily commercializable. These are, I think, deep philosophical questions that are happening in parallel. and being shoehorned in slightly into a panel about AIDA, so I'm going to be mindful of the awkward transition here. But one that I think is important is that we want to talk about this kind of way, this delegation. I think that's a central question. I think a central part about what's going to make or break this bill is who kind of ultimately is going to stand to benefit from this. And Bianca, you raised it. There's likely going to be an auditing industry coming about this. And Marussia, I wanted you to talk about, what would be this delegation question? Who are the stakeholders that are likely going to benefit from the way that AIDA is currently constructed, and what's going to take place if this goes forward? Like, what'll happen are the next steps?
Thanks for this. I guess 2 lines of reasoning. First is we can't give the government a blank check to have sort of TBA content in regulation. Those regulations are going to be vulnerable to being revoked. The process for public participation in the law was already lacking. It's going to be even more opaque and inaccessible if the meat of the obligations are in regulation. So that's kind of one line of reasoning. The other, going back to sort of the auditing question there, is, as you said, who stands to benefit from this? Well, if you are a cynical person, you would say, well, industry folk are just going to hire auditors that are going to rubber stamp their practices. There is some sort of precedent for that. We've seen it with the Volkswagen case where auditors just, rubber stamp their gas emissions, which were fraudulent, because who pays them? If your client is the AI company or whoever is putting it out on the market, then you don't really have a good incentive to push back. And here is where the AI Act in the EU is a bit more kind of balanced, because auditors depend on the public certification to operate. So if they just rubber stamp, they lose their license, they lose their business. There's nothing like this in this sort of skeleton of a bill right now. I don't mean this kind of derisively. I think that we can all agree that ironically it is more of a blueprint than a law, whereas in the US they put out a blueprint that's not binding, but that's much more detailed than this. So kind of like looking at this from a practical perspective, who stands to benefit is the established auditors, people who already have a track record. Will probably get their lion's share here, and this will make it a stagnant space. There isn't really a lot of sort of new, fresh perspectives that are going to come out from the same firms that have been writing reports about AI, sort of rehashing the same sort of high-level content there. However, I do want to flag that I think this is a really interesting space for people to move into. We have a couple of companies that are starting out to do audits from a sort of a more critical perspective, I may say. There's Kathy O'Neill and Meredith Broussard in the US that have started one. And I guess I would invite our Canadian fellows to do so. And there may be some companies that are already involved in this. I'm seeing some enthusiastic nods here, so maybe people can plug in their companies in the chat. But I think that this is a point of intervention. No matter what the trajectory of this law, if you have technical expertise or legal expertise and you want to contribute to shaping this, assuming it goes forward, and we can talk about whether that should go forward or not, this is a place where it has potential to have a counterweight. If it's a thorough, independent audit, then we may get some of these obligations actually followed and respected.
Can I add one point? The bill requires audits only if the minister has reasonable grounds to believe there is a contravention to certain sections of the act. And in addition to that, the audit can be done by the company themselves internally or by hiring an independent auditor. So just that point blows my mind. The first time I read it, I was like, this is so wrong. And also on a cynical side, it would be a great time for me to open a company that claims to be doing auditing services. So the fact that there's no standard or certifications about who can do and conduct an audit, and the scope of the audit itself, who will be able to mandate those types of details, leaves so much room for conflicts of interest to rise up, because the minister has to himself declare that, oh yeah, I have reasonable suspicions that this company has problems. I don't see how this approach would benefit people and communities here at all.
All right.
Yeah.
Well, we're approaching the end of our time, and I wanted maybe Christelle as to kind of start wrapping this up, maybe to get a last word in about just what are the steps forward for you. I mean, as someone who has been calling for reforms to the bill, has also been calling for more time. I think one part, we're at a very important crossroads because there's push now to get this passed and passed soon, and yet there's need clearly for more consultation, discussion, to have something what I think that Bianca says, can actually build trust. And if there is a serious, duty of making sure that there's building trust, which is a gap in Canada, and then it's got to be one or the other. You can't rush the bill and then expect people to trust it. But I think more broadly about the next steps for AI governance, I was wondering, what would you see, Christelle, as maybe a kind of closing word, and then we'll go to questions. What do you see these next steps to be?
So right now the bill is in the first reading at the House of Commons, meaning that MPs are voting to see if it should be going to committee or not. If it goes to committee, I want the committee to look at the law and then realize, oh no, there's no public consultation. Let's mandate that to ISET to run a public consultation. And then if they want to come back, let's say after 6 months or a year with a new version of the bill, then continue working on that. But I don't foresee that happening because the bill has been presented last summer. It's been almost a year, almost 10 months, whatever, that there's been no movement in the House of Commons. So I'm really concerned. I think where we need to begin is a public consultation. We need a better relationship with our democratic institutions when it comes to the relationship we're trying to build with technologies. This is where I would start.
All right, Florian, I just see your hand up.
Yeah, just some thoughts of first to reply to what Bianca says. Yeah, this is basically government by press releases. And when you look at the press release for AIDA, this is an amazing proposal. Then when you look at the bill, all those amazing things that Mr. Champagne announced in the presser, what is happening? And I might be wrong, but I have that feeling that this is kind of a last minute bill. They wanted to do something happen, maybe in a global conversation, with G7 or G20. They wanted to have something. And basically, because it's so complex to how to regulate, what to do, what kind of rights to take into account, what to delegate, they decided to delegate everything to regulation to be able to table something. And they just rely on criminal jurisdiction to make sure that it was standing the constitutional test, which is an issue because, as Marussia said, there is more in the blueprints published by the White House than in the Act and the companion document published by ISET. And at the moment, the biggest issue is that AIDA, I believe, is blocking C27 to go forward. So right now, C27 is in second reading within the House. And last fall, the Speaker ordered the actual study to be split in two. So CPPA and AIDA, noting that the two bills were so different, it almost makes no sense that they were in the same document, both C27. And this is the issue because we need both, but we might end up having nothing because of AIDA. So yeah, the government need to go back, in my opinion, and Marussia and I, we committed an essay that is soon to be published in the coming days by CG, where we expand on this. This is why she could quote me a bit more a bit earlier. The government need to go back to the drafting table, for AIDA, but we need to find a way to go forward with CPPA. That's urgent for candidates.
And I think that's been, Florian, if I'm getting you correct, that some of that for people to know, there's been calls to split. So to move forward on C27 and hold AIDA in a way that's a meaningful fix, so to speak, that's trying to make this balance between the two. So I think that's just something that people should know is one of the options on the table here is having a carve out, having a separation, trying to separate these two. I want to take a point from Dr. Andrew Clement, asking a question of what would going back to the drawing board look like in practice?
it would start by consulting people who are most likely to be affected and vulnerable with regards to the impacts of AI-driven harm. So the government went about this kind of the reverse way, right? And it tried to course correct. The companion document is part of that. But what we see is that right now we're at a very narrow path where we haven't really explored the full array of possibilities to deal with these harms. So legislation is one way of doing it, but there's a plethora of other kind of alternatives here. So going back to the drawing table would be blue sky thinking, like what about a compensation scheme, a public compensation scheme, something like the no-fault driving system when you're in Quebec driving. So you're not wasting your time trying to figure out whose fault it is. You know there are going to be harms. When somebody is harmed, they are compensated. So that's just one example of a completely different way to go about doing this. So I think that it would start with listening to people who have not been heard so far in this. And maybe there's going to be a political cost for going about this sort of the other way around. So I'd start with this.
Thank you so much. So we're well over time, so I will close it now. I just want to acknowledge the thank of Lindsay Rogers, who helped make this event possible. Also the great team at Fourth Space for making this event so seamless. It's really remarkable. And I think I'd also just like to say, and thank you, you can join me virtually in thanking our panelists. It's really fantastic to learn and listen to all your great insights. And with that, with that, I'll pass it off. Thank you very much.
Thanks, Fenwick. I have nothing more to say except for so wonderful to have the Applied AI Institute come through Fourth Space all season long with these excellent conversations that you can all revisit on our YouTube channel as they're already available there now. We'll close up now and wish you a great evening. Thanks everybody for your participation, your insights. Bye.
If you have an idea for a podcast, please let us know. You can contact us by email at info.4@concordia.ca or find us on social media at CU Fourth Space. All social media is managed by Jacqueline Wexler. This episode of the Fourth Space podcast is hosted by me, Maximus Delmar, and produced by Anna Voklavek and Douglas Moffat. Editing by myself, Douglas Moffat, and Chanel Lees Marshall. Additional thanks to Supercontinent for providing our theme music. Thanks for listening.